I do want to start by saying that this subcommittee does work that tends to be bipartisan, so that's more than refreshing. It enables us to get things done. And on the topic of injunctions, I am a strong supporter of patent rights, especially the patent rights of small inventors, because I am also told that a lot of our competitiveness comes from the work of small inventors. And I am all for enabling them to effectively protect their inventions. I co-sponsored the Stronger Patents Act in previous years and am inclined to support this legislation as well. And I think back to, these many years ago when I took property law, and my professor described property law as being a bundle of rights, and the most important of these rights is the right to exclude, and we won't even get into the rule of perpetuity and all that. So, property, the right to exclude, and that is what we're talking about with, I would say, injunctive relief. So it seems to me that I don't see how a decision like eBay could not have some sort of an impact on business dealings, because often the remedies that are available really turn on who bears the burden of going forward. So under eBay, the burden lies with the inventor it's already been deemed that his or her invention has been infringed upon, and now the inventor bears the burden of showing that an injunctive relief should ensue. So that is a pretty tough burden to bear. So I don't understand how it is that the eBay decision could not have the effect of making it a lot harder for inventors to protect their patents if it's much harder to get injunctive relief. And I do recognize that Professor Country, I'm sorry, is it? Yes, Cutchers. So you cited to, I think you cited to that we don't really have a problem here, but I can't see how we don't. And so I think I'd like to ask Mr. Babcock, the non-lawyer in the group, right? Okay. So over the past decades, as far as I'm concerned, we've seen a number of efforts to weaken patent rights. I think that's been the impact of some of these laws that we've enacted. And I would cite the Supreme Court's eBay decision among those. America Invents Act, I'm one of the few people that voted against that act because I thought it had a negative effect, especially on small inventors, to the growing number of things that are not patent eligible. So for Mr. Babcock, what has the weakening of patent rights meant to innovative companies like yours and the startups that you support?
Yeah, thank you for the question. And I want to go back to something Mr. Tilla said and add to it. The inventions that we don't see are the most important ones that we're missing, and it's really hard to quantify those. But where I think you see it showing up is in the lack of venture capital that goes into those businesses, because venture capitalists and angel investors cannot rely on patents as strong property. Mm-hmm. If venture capitalists were able to rely on intellectual property, they would be able to invest in the most promising people and the most promising technologies, because they could do the scientific diligence to understand if this is meaningful. But the problem is today, you can invest in great, meaningful, exciting technology, but you don't know as a business person if you'll ever have the ability to monetize it. So I think it's not showing up as big of a problem as it actually is, because it's really hard to measure what's missing.
I tend to agree with you. So what would passing this measure mean, both financially and symbolically, if you want to think of it that way, to innovators?
Yeah, I think it's one step in the right direction. I think the pendulum has swung dramatically over the past 20 years. You mentioned the legislation, you've mentioned some court cases, and there's also administrative changes that have happened. This would be a step back in the right direction, get the pendulum swinging back towards a more moderate middle system. And there's more that needs to be taken care of. I think the PTAB is particularly problematic, but this would be a very good starting point because it shifts the burden back to the defendants. They can still have they can still avoid injunctive outcome, but they have to be the ones that prove it. And I think that's a fair way to put it.
I agree with you, because I don't see why the infringer should not have the burden of going forward regarding whether an injunction should ensue. Thank you, Mr. Chairman.
Thank you, Senator Hirono. Mr. Babcock said